On behalf of IISD, I'm glad to welcome you to this webinar on Rethinking of National Investment Laws. Today's webinar is part of a long-time initiative of IISD to promote responsible investment governance while developing initiatives, tools, and capacity building services to support developing countries in improving their investment legal and policy frameworks. But let me start with some housekeeping mentions. Today's webinar is public and will be recorded. The recording will be sent to you post-event, which you are very welcome to share with colleagues who couldn't join us. And after the panel discussion, we will have a Q&A session. Please feel free to type your questions in the Q&A box. You also have a possibility to listen to the webinar in French or Spanish, as we have live interpretation. You can change the language channel by clicking on the globe button at the bottom of your Zoom screen. Let me now turn to the topic of today's webinar. This webinar follows the launch of the IISD's new report, Rethinking National Investment Laws, a study of the past and present laws to inform future policymaking. My colleagues will soon share a link on the full report and the executive summaries on the chat for your access. And if you are with us today, you likely share an interest in investment laws, right? Which are unique, but yet diverse policy instruments widely used in developing countries. Strangely enough, national laws have frequently been sidelined in conversations about international investment governance, where the focus often turns around investment treaties, investment contracts, and the dispute resolution mechanism. However, we think it's crucial to acknowledge that poorly drafted investment laws also pose significant risk for policymaking and dispute in international investment governance. At the same time, when properly crafted, national investment laws, we think, can help governments achieve sustainable development goals and encourage responsible investment within their territories. As the report notes, there can be numerous triggers that may bring investment laws to the attention of policymakers. They may then decide or consider adopting a new law, reforming a current one, or even replacing investment laws with other policy tools. So it's therefore important and timely to focus and channel reformative efforts into these policy tools. But to engage in a meaningful assessment and reform, much like for investment treaties, we must clearly comprehend first investment laws past to effectively understand the present, so we can strategize for more efficient approaches and better outcomes. Indeed, where do these instruments originate from, and what implication does that have for us today? Through what lens should we analyze the content of current laws? Furthermore, how and where to start when assessing and, if necessary, reforming investment laws? These are some of the questions we discuss in this webinar today, and we hope the discussion will help policymakers and relevant stakeholders assess and rethink their national investment laws so they can be calibrated to face the current challenges of investment governance. And at IISD, we are excited to embark on this journey, hopefully in collaboration with significant partners in the field, to offer capacity building and advisory services to developing countries, equipping them to navigate these challenges and adopt meaningful reforms. Without further ado, I will pass now the floor to my colleague, Joseph Ostrensky, policy advisor at IISD, who will introduce and moderate our estimated panel. Over to you, Joseph. Thank you.
Thank you, Susie. Good morning, good afternoon, and good evening, everyone, also from me. And thank you for joining us today for what we hope to be a very exciting webinar. And I would like to start with, in a way that has now become customary to start IISD webinars, and that is to first gauge your views, the views from the audience, on the topic of investment laws with a short poll. My colleague Kudzi Mataba will guide you through the poll that will shortly appear on your screens and then reveal the poll's results. So over to you, Kudzi.
Thank you, Joseph. Good morning, afternoon to everyone. I am starting the poll now. You should be able to see it on your screen. Joseph, could you confirm if you see it?
Yes.
The first question on the, thank you. So we can proceed. The first question is, when and where was the first known investment law adopted? And then you have a series of answers there. The first one being in 1950 in Israel, the second one in 1950 in Peru, in 1955 in the Federal Republic of Germany, in 1958 in India, or 1963 in Ghana. I think I'll give participants about 30 seconds to go through the answers, the possible answers. So I'll repeat the question one more time. When and where was the first known investment law adopted? If you give me a bit more time, Joseph, it seems people are still answering the question. Okay, I think that's fine. The second question, what is the sector you work in? And the options there are government, civil society, academia, private sector, or business or private sector, legal practice. And then the next question is your country currently reviewing or has recently reformed your national law? And there are 4 options there. And then finally, what do you think are the most important functions of investment law that an investment law should serve? And there are multiple options possible, so you can select more than one answer for the final question. And if you have access to all 4 questions, then you can have about another 30 seconds to complete. Okay, thank you everyone for participating. I see some people are still putting in very last minute answers. I'll give you 2 seconds to complete. About 50% of participants have shared their answers. Thank you. And here we have the answers to the poll. The first one, when and where was the first known investment law adopted, with the majority of answers selecting in 1955 in the Federal Republic of Germany. The next question, what sector do we work in? We have majority of participants from government today. And then, is your country currently reviewing or has recently reviewed your national investment law? Most participants selected reforms occurred in the last 10 years. Also, a significant number said they have no self-understanding of investment law. And then finally, what do you think are the most important functions of the investment law? The majority of participants answering governing admission, approval of foreign investment, followed next by investor obligations, CSR, etc. And then monitoring and oversight had a good percentage, and so did investment incentives. I think that's about it, Joseph. Thank you.
Thanks so much, Kuzi. I think this gives us a very interesting start of the discussion, which will now continue with our panelists. And for those who are interested in the correct answer to the first question, I'll just refer you to the new report, which we're going to be discussing today. And the link to the report will appear in the chat shortly. So I'm really delighted that we're able to discuss this fascinating topic with our distinguished panelists today, who are prominent experts on investment laws and investment policies, and who I would like now to introduce. I'll start with Massimo Meloni, who is a coordinator at National Investment Policy Section at United Nations Conference for Trade and Development, UNCTAD. Massimo has many years of experience in the field of national investment policies and has been responsible for leading the preparation of UNCTAD investment policy reviews for developing countries and also coordinating follow-up technical assistance programs at UNCTAD. Welcome, Massimo.
Thank you very much, Joseph. Thank you, Susie and everyone. And it's a pleasure to be here with you today.
Thanks, Massimo. So our second speaker is Hélène François, who is a legal advisor, investment policy analyst, and a regional program manager at OECD's investment division. At OECD, Hélène has been managing bilateral cooperation projects on business climate and investment for development in various MENA countries mostly, and providing legal and policy analysis for OECD investment policy reviews, as well as technical assistance on the topic in, for instance, Southeast Asia and Sub-Saharan Africa. So great to have you with us, Hélène.
Thank you very much, Joseph. Thank you, Susie. I'm very glad to be with you today. Thank you.
Thanks. And apart from our esteemed guests, we also have with us no less distinguished authors of the new IISD report. And you have already heard from Susie Nikema, who is one of the co-authors, but we also have with us today Jonathan Bonnicia, Associate Professor in Law at UNSW, University of New South Wales, School of Global and Public Law, and a Senior Associate at IISD. And Taylor St. John, who is a lecturer at the University of St. Andrews, School of International Relations, and researcher at Pluricourts, a research center at the University of Oslo. So welcome, Jono and Taylor. So before we dive into the discussion, I just want to remind you and encourage you to write any questions you might have either on the discussions that will unfold shortly or on the report into the Q&A box at the bottom of the screen. And towards the end of our webinar, we'll do our best to get to all of your questions. So now we'll first hear from Taylor, who will give us an overview of the report and go through some of its main findings to frame the discussion. So over to you, Taylor, floor is yours.
Wonderful, thank you very much, Joseph. And hopefully you can all see my screen. Yes, I think this should be working now. So it's wonderful, it's really wonderful to be with you all here today. And on behalf of Susie and Jono, I just wanted to briefly introduce a few main points from the report before we open our discussion with the panelists. And so I want to start with a few words about the motivation for the report. So our goal was to provide evidence about how investment laws started, which countries have investment laws, what features they have, and then on the basis of this evidence, draw out lessons for policymakers, for you in the audience, who may be thinking or thinking about reforming their investment laws. And so today I want to introduce three main lessons that we've distilled from the report for policymakers. And the first of those lessons is that national investment laws vary widely. And it looks like, okay, is my screen now full screen? Yes, I think it should be. Sorry about this. I'm having some trouble with my screen. Can you all see my screen just to check?
Yeah, it's not in full screen, but we see the slide.
Okay. Sorry, let me see if I can put that in full slide. Okay, that should be better now. Thanks, Joseph. Our first finding is that national investment laws vary widely. So some laws, like China's 2019 law, for instance, seem to have been designed as a tool of domestic economic reform. Other laws, like Myanmar's 2016 law, seems to have been a kind of signal of regime change. And one thing that we noticed is that many countries, like Myanmar, draft new investment laws during moments of high-level political or policy change. And we found that other laws, like Australia's, serve a relatively narrow purpose, and it only establishes a framework for foreign investment screening. And finally, there are still other laws, like South Africa's law, for instance, which seems to have been envisioned as a partial substitute for investment treaties. And so what we take from this is that national investment laws are really versatile policy instruments, and they can be, and they are often designed in different ways to fit different national contexts, different policymaking contexts. So then the question that we asked is, how can we make sense of this variety? And so in the report, we suggest focusing on the functions that a law is intended to serve. And this is a little bit different from, I think, how these laws have often been understood, because often you as policymakers consider, say, the objectives that a law pursues, for example, promoting sustainable development, right, or coordinating across different government, different departments or ministries within government. Then often, probably as policymakers, you move on to questions of content, right? Many of you are probably lawyers, so you think about how to draft or structure provisions. But we suggest in this report that there's an important middle step, which you see on the slide here, which is functions. And so after surveying around 70 laws that are in force today, we suggest that there are 7 main functions that laws serve today. And you see those 7, of course, on this slide here. So first, laws can govern the admission and approval of new foreign investment. And at least 60% of the laws that we reviewed dealt with admission, but there's a lot of diversity in how they govern admission. So many developed countries, of course, have investment screening laws that only serve this function. A second function that laws can have is to confer and administer investment incentives. So many of you will be familiar with this. Around 80% of the laws that we reviewed do this. But again, how they do this varies widely. There's a lot of diversity in the sectors or the processes or the eligibility criteria for investment in national laws. Third, investment laws can facilitate investment. So one way some laws do this is by establishing one-stop shops for approvals or permits. But of course, there are other ways of addressing facilitation issues as well. Fourth, laws can guarantee legal protection to investment. So roughly 70% of the laws that we reviewed guarantee some legal protection to investors, but usually domestic laws do not contain the same range of provisions that are found in investment treaties. So these protections can be different. And of course, there's a lot of variation in different countries' laws. Fifth, laws can specify or manage a system for investor-state disputes. So here again, most laws address dispute resolution that we surveyed, but they do so in a variety of different ways. So some laws establish new national institutions to prevent or resolve disputes. Other laws assert the primacy of domestic courts, and still other laws recognize the possibility of international arbitration, with some laws even providing consent to arbitration. Sixth, some laws specify, or one thing that laws can do is to specify investor obligations and responsibilities. So investment laws are only one part of the domestic legal framework governing investment. And some laws just clarify that this is the case, while other laws place obligations on investors that go beyond what's contained in other laws in the domestic legal framework. So again, some laws, many laws specify obligations, but they do this in different ways. And then the seventh function that laws can have is laws can outline processes for monitoring and oversight of foreign investment. So some laws, for instance, will place obligations on investors to report to a particular agency, perhaps an investment agency, about their compliance with certain domestic laws. So these are the 7 functions that we thought often came up in investment laws. Some laws address just one of these functions, others address many. But we think that functions are a helpful way to understand the variation within investment laws. Our second lesson for policymakers from the report is that which functions countries' laws, investment laws include, have often changed over time. So countries' laws have changed as, for instance, countries' policy priorities or their level of development have changed. Governments have often used this as an opportunity to redesign their investment law. And so to address the first question that Kudzi asked you in the poll, the first domestic investment law was not put forward in Germany in the 1950s. It was one of the first laws was definitely put forward in Israel. Other laws were in Turkey. Many African countries were very early adopters of investment laws. So one thing that we've seen is that developing countries have for a long time been innovators, been leaders when it comes to investment laws, their purposes, what they could do. So following this, many African and Asian countries enacted their first investment laws in the 1960s and 1970s. So these laws may be older than you were thinking. And in the 1960s and 70s, the way these laws were drafted was often driven by domestic priorities. So then in the 1980s or 1990s, many countries rewrote their investment laws, often in ways that sort of realigned these laws with the content of investment treaties. This, of course, introduced some of the same risks that exist in what we think of today as old-style investment treaties. And so this is something that I think will come up later in our discussion. But one thing that we, as the authors of the study, wanted to underline is that laws have never been as homogeneous as treaties. There has always been a lot of diversity within investment laws. And there has always been quite a lot of change within investment laws. So some countries have updated their laws several times, especially if they have gone through transitions, right? Or if their economic circumstances or their policy priorities have changed. Often investment laws can and are designed or then redesigned to address their changing policy priorities. And this, of course, leads to our third main lesson for policymakers from the report. There is no off-the-shelf model for the functions and design of an investment law. Appropriate design varies by context, and of course, it varies by the function or functions that policymakers want their law to serve. And so in the report, we provide a framework to aid you as policymakers in thinking about national investment laws, what purposes you want them to serve, what functions you want them to serve. The framework that we provide in the report does not recommend a specific design. It does not recommend specific content, nor does it necessarily assume that an investment law will always be necessary or appropriate in all circumstances. Instead, the framework is there to help you ask useful questions and to help make sure that your government is deliberating thoroughly as it thinks about or redesigns an investment law. So the framework appears fully in the report, which you have a link to in the chat. But here on this slide, you just get a sort of high-level summary of the sorts of questions that the framework asks. So first, the framework suggests that policymakers clarify objectives, right? Then, once the sort of high-level objectives are clear, the framework suggests policymakers spend time articulating and evaluating the functions served by the current law, right? So how is the current law actually operating in practice, right? What consequences is it having on the ground, do we think? Next, the framework suggests agreeing on desired function for the revised or the new investment law, if you want to go forward with one. So for instance, a sort of question that could come up here is, do we actually want to provide investment incentives? Do we want to provide investment incentives to all investors, to just certain sectors? What does the academic evidence, what does the policymaking experience on this point say? Then the framework suggests comparing policy tools. Is it more effective to provide incentives, if we want to provide incentives, in our regular tax code rather than a special investment law, for instance, right? So there are multiple policy tools that can be used to achieve the desired functions. Then next in the framework is to design the structure and content of the revised or new investment law in ways that really serve those desired functions, perhaps using past experiences or other countries' experiences as evidence in the policymaking process. And finally, the framework suggests considering the risks or the implications associated with particular functions or with particular content in investment laws. So it this also includes thinking through what scenarios might arise in the future under the new law. How would the new law shape or create issues or solve these various scenarios that might arise? So there's much more to think about, and I think there's much more that will come up in the discussion, but I'll leave it there so that we can hear from our panelists and start that discussion. So back over to you, Joseph, and I'm sorry for my earlier issues with the slides. Thank you.
Thank you so much, Taylor. I think this was a really, really useful, helpful overview of the report and its main findings, and it will be great to frame our discussion today. So I would like to turn now to our two panelists, Massimo and Ellen, and to tell us a bit more about how they view the report and its findings in the context of their work at UNCTAD and OECD respectively, and perhaps a way to link this to your work in the space of national investment laws would be to ask you, how has the approach and policymaking regarding national investment law changed in the recent years, and why this could have been? What are the main changes you've been witnessing in your work at OECD and UNCTAD on national investment laws? And let's start with Massimo. I'll turn to you. Floor is yours, Massimo.
Thank you very much, Joseph, and thank you, Taylor, for the presentation of the findings. Let me start by congratulating the whole team on such an excellent report. It does fill a gap in the literature about investment laws. It provides a great overview of not only of the history behind the evolution of investment laws, but also their role and functions. But it primarily provides an innovative approach from the standpoint of policymakers as to how to go about thinking of investment laws, their reform, their introduction, their needs, etc. So I believe from my standpoint, we are very much aligned with the most, if not all of the considerations you have in the report, and it's going to be also a useful tool for us who provide technical assistance to countries on a daily basis in the reform of their investment laws. So just to give you a bit more of background as to what we do in this area, as Joseph said, I was working for over 15 years with Investment Policy Review program of UNCTAD. This is an advisory service that tackles not only the investment-specific legislation, investment laws, international investment agreements, etc., but also the reform of the general climate affecting investment in responding to government's request to attract more FDI for their sustainable development objectives. So in that context, I had the opportunity to provide assistance to over 30 countries at different levels of development across the world. And in each case, we did take quite a deep look at their investment legislation. And as you say, and there is no one model, there is no single model of investment law, and each country really has to go after the law if that is required and that is necessary for the country's context, an investment law that is customized to their needs and objectives. But recently I moved to the National Investment Policy section of UNCTAD, where we study and monitor investment policy trends, not only the cataloging of investment legislation, and I'm pleased to see that that was helpful in the preparation of this report. So we have in our investment laws navigator over 130 investment laws mapped by main provisions. But we also, of course, conduct research on the investment policy trends at the world level and on selected topic, contributing to the World Investment Report and other publications and studies, including with the OECD. And finally, we do provide technical assistance to countries on the reform of their national investment legislation. And this is why, again, the policymakers' perspective is key in our work, and why this study is so relevant. So, to address your question as to what changes we have seen in the area of investment policy making recently, I can say that maybe the biggest change over the past years has been the convergence of investment policy making between developed and developing countries towards a model that mixes liberalization and regulation to achieve certain industrial policy objectives. And this is because since the 1980s and 1990s, we have seen developing countries shift from extensively regulating FDI through pre-establishment restrictions towards the model that emphasizes liberalization of FDI entry combined with more sophisticated post-establishment regulatory frameworks on the one hand. And on the other hand, we've seen developed countries that previously embraced a liberalization model combined with post-establishment regulations that are increasingly imposing entry restrictions on FDI over national security and other strategic concerns. So I do agree with the fundamental message of your report that the old framework to assess investment laws by distinguishing between those that went after promotion of investment and those that were aiming at regulation of investment does not make much sense anymore neither from the analytical standpoint nor from the technical assistance point of view. So this being probably the main change I've seen in my experience in dealing with investment laws is also reflected in the type of policy documents that countries are looking to introduce or reform. Beyond investment laws, we see an increased interest by countries to introduce national investment policy documents and statements. And we have assisted in the past 5 years over 8 countries in formulating national investment policy documents. In many ways, these documents reflect the content of investment laws, but at the same time, they also reflect the willingness of countries to actually put down what their expectations are vis-a-vis investment. What are the key sectors in which they would like to attract investment for their sustainable development, and what obligations would they like investors to comply with. So again, no longer liberalization versus regulation, but more a mix of the two with industrial policy objectives in mind. And I think I will stop there because I tend to be a bit long.
Thanks so much, Massimo. So, Ellen, from your perspective at OECD, would you concur? Is there what is your view and from your experience on the recent changes?
Yes, thank you very much, Joseph. Well, first, I would like to echo Massimo in congratulating you for this excellent report, which really, well, I believe in my knowledge at least, provides a quite an unprecedented analytical framework and much needed and much awaited analysis of investment law policymaking. I also believe that it provides a very useful practical guidance for policymakers to think in a more rational way, perhaps to adopt a more rational approach to investment lawmaking by linking the overall policy objectives to the actual content of the investment law. So it's really useful, and I was very impressed, so congratulations. And also the historical approach, allows us to, sheds light on the most recent developments and on their raison d'etre, which is also very useful to rethink investment law policy making and to reflect on what function exactly it has to carry, right? So in our work at the OECD, we very much like UNCTAD actually at the investment division, we've worked a lot on investment policy and investment law over the past 25 years. First, through the investment policy reviews, which provide an overall analysis and diagnostic of the investment policy climate. On the basis of a methodological tool, the policy framework for investment, which is less focused on investment law policy making, so more broader and less, which goes less in detail on investment law. And historically, we focus very much on investment treaties, but we've shifted slowly towards paying more attention to investment law, to domestic investment law over the past 10 years. We also work with countries through bilateral technical assistance projects and policy advice by providing policy advice to countries when revising their investment laws. And so the main changes we've seen in the past years, I would say, is perhaps, at least in the countries with which we've worked on investment laws, which are developing countries, a lot with MENA countries, as you mentioned, Joseph, but also with Southeast Asian countries, with Myanmar, and also a few sub-Saharan countries. We've seen less focus on protection provisions with a progressive introduction of investors' obligations. So even so, it remains, in my opinion, quite a timid shift towards introducing investors' obligation. It's still, I believe, a signal of a willingness, of a political willingness to have a more balanced approach between investors' obligation and investors' rights. So yes, so we've seen a clear willingness to adopt a more balanced approach, even so these investor obligations provisions are very often remain merely hortatory. It's also perhaps not enough yet, but we still see this development because the monitoring and evaluation of investment, which you mentioned as one of the key functions of the investment law, is very often not well implemented enough, perhaps not functional enough to allow investment policymakers to actually make a link between the obligations of investors and their rights. We also see fewer laws covering foreign investment only, and an increasing number of laws that provide the same provisions to domestic and foreign investors, with less discriminatory provisions for foreign investment, or less guarantees provided to foreign investors. Which brings me to the last observation, is that we see stronger disconnection from international investment treaty provisions and more autonomous domestic legal provisions, which are less drawn on the provision of international investment treaties. So again, I would like to congratulate and really praise your report, which I think is going to be very useful, not only for policymakers, but for us, international institutions, in thinking of ways to provide technical assistance to countries with which we work.
Thank you so much. Well, this is really interesting to see that on the one hand, we see some sort of convergence between developed and developing countries, but on the other hand, we see this disconnect or increased disconnect between the treaties and the regulation they provide and the national investment law, and increased diversity there. So I would now like to turn a bit more into the content of the report specifically, and I would like to ask you to reflect a bit precisely on this sort of new approach that the report suggests, and that is that three-level analysis, looking at the level of objectives, looking at the level of functions, and finally at the level of specific content. What, in your view, is gained and what is perhaps lost when moving into this approach of functions, objectives, and content when analyzing investment law? And why do you think it could be helpful, and where perhaps a different approach might be more appropriate? And with this question, I'll start with Alan now. So back to you, Alan.
Thank you, Joseph. So I see a lot that can be gained from it. Not much that is lost actually from by drawing on this analytical approach. Well, first, I really like the fact that you're actually focusing on function instead of going straight from overall broad policy objectives to the actual content of the law. This approach I believe helps us to identify functions that should not be in the law, right? Should not be functions of these laws, right? To identify also what should not be, to better delineate the content of each of these functions, and also to rationalize the way we approach investment laws, and to move away from seeing investment laws merely as political tools to signal a political stance towards investment, especially towards foreign investment. What is lost or missing is that if we focus, to start with the objectives, we start by focusing on what is wanted by policymakers and perhaps less on what is needed. And here I was wondering whether the issue of the issue of coordination with other governmental institutions or other functions of other laws is well reflected in this analytical matrix, analytical approach. But perhaps I did miss something myself, and I would be very interested to hear your feedback on that. What else? Yes, again, like to dezoom from the objectives, focused approach really helps thinking having a clearer view of the actual role of investment law within the overall regulatory framework, regulatory landscape, not only for investment, but for business climate, etc. And so perhaps also to identify inconsistencies or inconsistencies with overall or redundancies with other laws as well.
Thank you, Alan. Massimo, I'll turn to you and your views on this framework.
Yes, thank you, Joseph. And I do concur with Ellen that the proposed approach makes a lot of sense, and it can be very helpful for policymakers wishing to reform or introduce an investment law. Now, maybe the challenge you may face with this approach is primarily that the distinction between the objectives and the functions may not always be as clear-cut as it appears in the report. We have gone to countries where the governing of the entry of FDI was considered the main objective of the law. So the introduction of the law was meant to actually regulate the entry of FDI. But clearly, it is objectives and functions which should guide the structure and the content of the investment law. And unfortunately, we often see laws that lack clear objectives, and that tends to result in provisions which are often contradictory within the law itself and with the rest of the regulatory framework for investment. Clearly defining the objectives and the functions that the investment law would perform is also useful to assess another important question, which is an investment law needed at all? And this applies to both those that already have one and those that are considering introducing one. So investment laws, as Taylor pointed out at the beginning, are very complex tools. And while they can assist policymakers achieve a number of important objectives, they can also pose severe challenges particularly when they are not coherent with the rest of the legal and regulatory framework for investment, both at the national level and taking into account the country's international investment agreements. So our technical assistance on investment laws starts with that question. It starts with asking the country, do you actually need an investment law? And the answer to that question is based, I believe, on three aspects, which are present in in your report, importantly so. And the first is to clarify whether the introduction of a law would strengthen the investment policy in the country in terms of the achievement of the economic, the social, the environmental objectives of the country. Second is asking what gap would the investment law fill in the existing regulatory framework? And third, whether that gap is best addressed through the investment law. Taylor, you mentioned the issue of incentives. Is it the investment law the best place to introduce incentives in a country? Often that's not the case for a number of reasons, which we can discuss if we will have time. But there is also the issue of investment laws introduced to, for instance, deal with the migration-related aspects of investment. So countries may try to achieve certain objectives by means of provisions in investment laws, which are better achieved through the other parts of the general legal framework for investment, be it the tax regime or the migration regime, etc. So once the answer to these questions are actually positive in the sense that, yes, the investment law is meant to achieve specific objectives and respond to certain functions, then we can move into the content, including, as you correctly point out, the scope. So who does it apply to? Would it apply to all investors, to foreign investors only? Different contexts and different objectives would deserve different answers in this regard. What is the scope also in terms of what type of investment is covered? Is it direct investment? Would it be equity? Would it be covering, would the law be covering mining and specific sectors, concessions, etc.? These are all questions which bear very significant implications for the host country. What kind of investment protection provisions, what kind of investment promotion and facilitation, etc., how to deal with obligations. So the content aspects are each very relevant, and you raise a number of questions for each of these aspects, which are absolutely fundamental. And that's where I believe that guidance and assistance from organizations like yours, like UNCTAD, IISD, can be useful to countries, because it can bring in the context about what the risks and challenges in the various structuring of an investment law can be, and also, of course, understanding what the objectives are to provide context as to what the most appropriate solution may be.
Thanks. Well, this is all very fascinating, and we can hear that the different frameworks, whenever they are put into practice, I mean, the context is always very important to see what are the specific objectives of a different government, what are the conditions, and to answer the question. So indeed, I mean, no one of the shelf option for investment law is there. Now, I would like to move to that second part of the report that discusses the specific functions, the 7 functions that we've seen in the poll and that we've heard Taylor presenting during her presentation. Are there any functions in your view that were missed, or any that should not perhaps be in the list based on your work, or is there any function that is particularly important given the current challenges that investment governance faces? I mean, we can think of climate change, but we can think of other different challenges that different countries can face. Massimo, I would turn to you now first on these questions about the functions of investment laws.
Thank you very much, Joseph. Yes, no, I think you have definitely identified the main functions, and that we've seen also through our research and technical assistance activities. If I had to think of additional functions, well, rather than adding one, I would expand probably on one of those you already have, facilitation. I would broaden the facilitation function beyond the narrow definition of basically streamlining investment processes. Investment facilitation in its acception, for instance, at the WTO at the moment, also takes into account all the aspects related to clarity and transparency of the investment regime. And I believe that this is a real key function of an investment law, in the sense that the investment law can be, for policymakers, for a country, a great tool to clarify the investment regime. This is particularly when the regulations affecting investment are scattered across several sectoral legislation, or are different between the national level and the local level, etc. So the investment law itself can be an opportunity to consolidate the conditions applying to investment in a single instrument, providing clarity and transparency to the investment regime. Related to that is an aspect that Ellen had already raised earlier, which is the transparency of the institutional framework for investment and the clarity of that one. And this is more a function that, yes, caters to investors, but also caters to the administration itself, to the government administration, because it is often the case that within a government, several different entities deal with investment promotion and regulation. Line ministries, tourism, mining, agriculture, etc. Investment promotion agencies at the national and local levels, special economic zones, etc. And these actors often have overlapping mandates, often put the face of the country towards the investors without a coherent message, etc. So the investment law can be the ideal locus to clarify the mandates and bring coherence and coordination in the investment among investment-related entities. Now, as to the functions that I believe are gaining prominence and are likely to rise in prominence in the next future, beyond, of course, investment facilitation, which, as you know, the investment facilitation for development agreement, well, the text of the future agreement has finally been agreed upon at the beginning of the month. So it's likely that we will see a lot more efforts by countries in that regard. And probably the investment law will be one of the channels for these efforts. Another clear trend is that of the increased FDI restrictions for national security considerations, so the FDI screening regimes. In the World Investment Report of this year, which came out at the beginning of the month, we measured to 68% of FDI stock the countries that have an FDI, a comprehensive FDI regime in place. And this trend is likely to expand in, I believe, in two directions. One is that an increasing number of countries, particularly developing countries, will start regulating the entry of FDI for national security considerations through dedicated screening regimes. And the second direction is the type of mechanisms, the type of investment that will be screened, because we see efforts by the United States and the European unions to develop a system for the screening of outward FDI. Such regimes are being considered by both blocs, and if they were to come into place, it is likely that they will lead to similar regimes also in other countries, and this is part also of the geopolitical situation we are experiencing today. And I'll stop there. Thank you.
Thanks, Massimo. Over to you, Ellen. What are your views on the functions?
Thank you very much, Joseph. So, well, very much in line with what Massimo said, I would have said that, well, you mentioned investment facilitation as one of the key functions, but I would have added something on investment promotion, which is distinct from investment facilitation, and I believe is missing in your matrix here. And within investment promotion, you could actually consider that incentives are part of the investment promotion function. Likewise, part of the dispute settlement and management provisions could be considered as part of the investment facilitation function when it comes to dispute prevention, for example. So, well, I see first that investment promotion might be missing, but that also the scope of the different functions could be delineated a bit differently. With clear links in between various of these functions. Then I think Massimo mentioned it, but I believe like one of the key functions of an investment law is to clarify the institutional governance and framework for investment promotion, facilitation, and regulation. It's de facto very often a key chapter of investment laws, and it's not reflected in these key functions. Then I have one comment, because it's a very interesting descriptive approach, but I wonder whether it can become, with time and by being used by policymakers, whether it can become prescriptive, actually, you know, these 7 functions, whether it can imply that all these functions should feature in an investment law, which worries me, because in a way, well, for example, and as Massimo mentions, at the OECD, we do not advise countries to insert investment incentives provisions within the investment law itself. We believe it's better either in a tax law or in a decree, in a regulatory tool, which gives policymakers more leeway to amend their incentives policy as policy objectives change over time. So I just have the comment and I would very much like to hear your feedback on that. Likewise, in terms of when it comes to the scope of each of these 7 functions, monitoring and oversight, I wonder why you say monitoring and oversight of foreign investment specifically, and I believe it should be of all investment to really link it to the investor obligations, you know. And I would suggest making a distinction between binding provisions and hortatory provisions, such as typically investors' obligation or monitoring of investment, which is not hortatory, but de facto is not directly enforceable. You know, it very often comes with the need to then introduce regulatory instruments. I think that's all the comments I had on these 7 functions.
Thanks, Ellen and Massimo. Well, this is plenty of food for thought, and I think that this is the right time that we give space to the report authors to respond to some of the points raised during the discussion. And for that, I would like to turn now to Jono to respond to some of the points raised. So over to you, Jono.
Thanks, Joseph, and thank you so much, Helen.
Muchas gracias, Joseph, y muchísimas gracias a Helen y a Máximo por sus contribuciones realmente generosas, muy comprometidos. Son expertos en el campo, así que es excelente contar con ellos en el panel de hoy. Estoy de acuerdo con todo lo que se ha dicho sobre este tipo de tendencias principales en el momento, en lo que tiene que ver con la inversión, así que simplemente les voy a agradecer por haberlo destacado y no voy a realizar más comentarios. Y también creo que estoy de acuerdo con casi todo lo que han dicho en cuanto a las sugerencias, las aclaraciones que han realizado ambos. Y sé que tenemos tiempo limitado.
Clarify our thinking as best I can. So one of the really important points that Massimo made is that in UNCTAD's practice, one of the first questions they're actually asking is whether a country even needs an investment law in the first place. And we agree this is really the starting point, and this is something that's sort of reflected further down in the detail in the report in section 4 in the framework we're trying to develop. So just to say, when we start talking about investment laws, sometimes that can, to use Helen's language, sort of come across as being quite prescriptive, but the starting point is that an investment law may not be necessary at all for many countries, that investment can just be governed through laws of general application and sector-specific or issue-specific regulatory processes and laws as appropriate. And that also, I hope, sort of answers Helen's really important comment that there's a risk that these 7 functions could be seen as a kind of prescription, an idea that maybe this is what should be covered by an investment law, which is really not our intention at all. And in fact, some of these functions we think are really ill-advised, incentives being the obvious example, where we have very serious concerns about investment protection functions, about, especially if they're designed in certain ways, about certain sorts of dispute settlement functions. So this is really not at all intended to suggest that these are functions that investment laws should have, but rather to say we found it helpful to make sense of the diversity and also to provide a sort of more structured framework to policymakers to think in terms of functions rather than just jumping straight from the question of what can be quite high-level objectives to very granular questions about the drafting of particular provisions, and that we think that the functions is a missing step, but that not to say that these functions are appropriate or necessary in the laws at all. And that leads me to the second point, which is one that Massimo highlighted, which is to say, well, sometimes it can be unclear what's really a function and objective. And I think we would agree that there's a bit of blurring here and there's no clear distinctions. But I guess for us, one thing that we found useful and one thing we tried to capture in the report is the difference between what is the law trying to regulate, that's a question of function, and to what end or for what purpose or to achieve what objective is the law regulating that issue, which is a question of objective. So while it may be the case that some laws, to use Massimo's example, describe in their own terms to say, well, the objective of this law is to regulate the entry of foreign investment, we would describe that as a function, not an objective, because that is the thing that is being regulated. So in our, I guess, conception, we think it's helpful to distinguish what issues is the law regulating from the question of objectives as we understand it, which is what are policymakers hoping to achieve by regulating those issues through an investment law. And I think that may help clarify you know, the way we see these sort of question of coordination between different parts of government and clarifying the legal framework, because we agree that these are crucially important objectives, and I'm using the word objective quite carefully here. These are really central objectives in our view of investment laws, and often one of the most important objectives a government is trying to achieve in an investment law is to clarify certain aspects of the regulatory framework and improve coordination between central agencies, line ministries, and sub-national levels of government. The reason I guess I would characterize those as questions of objectives rather than functions is because the function, at least as we see it, is the issue that is regulated. So if we're talking about admission, then the objective of coordination is achieved in relation to the function of admission by making a consolidated negative list, which provides an authoritative account of the sectors in which foreign investment is permitted. So through that content in the law, let's say it's a negative list that performs a function which is part of the governance of foreign admission of foreign investment, a particular objective is achieved, which is coordination between different ministries of government and clarity for prospective foreign investors. And if you think about it in that way, then it becomes clear that questions of coordination and clarification may arise in relation to multiple functions. So there could be questions of coordination in relation to tax and fiscal incentives, or there could be questions of coordination in relation to facilitation measures that may be taken at cross purposes in different parts of government. So the coordination objective then is a really, really central objective, but one where we still think it is useful to particularize functions as part of that stepped analysis. And I guess that sort of brings me to the final point, which is just to say, once again, you know, I think we're all really in complete agreement that these are the kind of central concerns in investment law policy making, and one that hadn't come out so far in this webinar. And I'm really glad that both Massimo and Hélène highlighted in important ways is this crucial question about the importance always of thinking about the relationship of an investment law to other parts of the domestic legal framework. So whether that's at the early stages of thinking about whether investment laws are even necessary, or at subsequent stages of thinking about potential problems that come from investment laws that are drafted in ways that are inconsistent with other parts of the legal framework, or even if not directly inconsistent, are not integrated in a sensible way. So is just to say that we agree that these are really crucial cross-cutting questions that can play out slightly differently depending on the functions involved, but are always going to need to be at front of mind for policymakers. But I'll leave it there, and thank you again for your really thoughtful and engaged comments.
Thanks so much, Jono. Now looking at the clock, I see that time's passing is moving quite fast. So before I would like to reserve at least 15 minutes for the Q&As from the audience. I see that we have already around 7 questions from our audience. So I now move to the last question, and I would kindly ask you to keep your responses short so we can discuss a little bit more during the Q&A. And that is essentially to ask about, if you were to choose one key policy recommendation for our audience today regarding investment law, which one would it be? So I turn to Ellen first.
Thank you, Joseph. Well, very much like what Jonathan just said and concluded by, I would say, I mean, my biggest advice would be when reflecting on investment law policymaking or revision, do not approach the investment law in isolation from the broader regulatory framework and pay attention to the coherence with other pieces of legislation. Otherwise, it has actually a deterrent effect, counterproductive effect to amend the new investment law. So avoid that at all costs. And meanwhile, emancipate investment laws from BIT provisions. That would be a big recommendation. And also to make sure that the investment law is coherent with the broader legislative framework. I would say do not overload the law with provisions of general intent or provisions that should feature elsewhere in other pieces of legislation. Thank you.
Thanks, Helen. Massimo, one quick recommendation from you.
Equally brief. And if I have to give one message to policymakers at this stage, it's probably about the process for adopting and reforming investment laws. You need to bring the whole country on board. You need a participatory process where you consult with the whole of government, as well as the stakeholders in the private sector, both foreign and domestic. It cannot be a law produced by a small regime that is imposed on all the stakeholders. It needs to reflect the national priorities, objectives vis-a-vis investment, the relationship between domestic and foreign investment, et cetera, et cetera. And so the process is crucial. It needs to be participatory, and it needs to be structured. And this is the same for the adoption and for the revision. Mind you that once you adopt an investment law, revising it, it's very difficult. If you introduce incentives or if you introduce entry restrictions, removing them or modifying them is going to be very hard. And again, I stop there and look forward to the questions.
Thanks so much, Massimo. I'll give one last possibility to Susie to also give her recommendation to our audience, and then we turn at 15:15 to the Q&As. Susie, floor is yours.
Thank you very much, Joseph. I mean, since we don't have so much time, I will try to be brief as much as possible. Even if I had many things to share and to react to excellent points by Massimo and Ellen. As Jonathan and Taylor said, we really appreciate your comment and intervention. I think we have already, and Taylor has already shared some of the key lessons learned that this report has provided, and I kindly invite the participant to read the last chapter of the report in that sense. But for a more practical view, what we would give as recommendation to policymakers is at least to follow this kind of three steps. You reminded Taylor said that unfortunately policymakers often jump from the objective step to the content. And so we think at least taking three steps will be very important here. First is get clarity on the function that your country's investment law pursues right now. And if, as we have said, an investment law is appropriate instrument for these functions. And I think that's really important because unfortunately, this question is not even addressed in the discussion. And we have seen also in our work with countries that sometimes the expectation from the revisions of investment laws misalign with what actually an investment law can deliver. So this leads to cycle of constant change with little tangible result and all the frustration that come with it. So we think really digging into the function will help choosing the appropriate one. And really, the result can be, of this assessment can significantly vary from one country to another. Some countries may realize they don't need to change the function. They are fine. Some may say, okay, actually, that's not the right function. We have to revise and change. And some may even conclude, actually, we don't need an investment law. So I think really taking this exercise is helpful in various ways. A second step, which I think is important, is, if I can put it that way, for policymakers, keep your mind open in selecting the appropriate function. Because we have said, as Jonah said, we have listed the 7 main functions we are seeing in the investment laws, but it doesn't mean it has to be this function or it cannot be something else. So be open to that, and as much as possible, avoid picking up the risky ones. And I think, as you said, Ellen, some function really come with some very high risk, and we have highlighted them in the report actually, particularly when there is a risk of inconsistency or overlap with other laws or regulation in the country. So really assess carefully when it's come to some functions. Last but not least, and this is maybe a more complex task, is of course, when you decide you still need an investment law and you have selected your appropriate function, make sure to design the right approach to implement them, because that's also another issue. Sometimes the objective is right, function is right, but the content is not aligned at all with the function and cannot serve to deliver the intended result. So that's, if I can put it in that way, 3 main steps we think is very important and which constitute a kind of lesson learned from this report. And to conclude with that, I think this exercise is not only important for countries already in the revision process of investment law, but even for those who are not doing so right now. Because actually, if you try to do that, you may realize and have to take some specific action regarding your existing investment laws. And I will stop there. I was much too long, Joseph. Thank you for your patience.
Thanks, Susie. So I think that now it's time to open the floor for the questions from the audience. And for that, I'll turn to my colleague Kudzi again, who's been following the Q&A box to tell us what questions have landed there. Over to you, Kudzi.
Thank you, Joseph. Picking up from where Susie left, I think the first question we can address that was posed by Paul is about what should precede the other policy or the law. I think Susie has, to a large part, already begun to allude to the answer there. I'm not too sure if any of the other panelists would like to say anything more about the relation between policy design and the law.
Yeah, I think it was the question that related to the national investment policies. I think that Massimo alluded to that as a trend that it's been raising, and the relationship between national investment policies and investment laws.
Yes, I'm not sure I got the full question, but I think the two are separate tools. They can coexist or not, in the sense that once more, in our experience, we have been advising countries that have a sufficiently comprehensive legal regime for investment, not to go for an investment law, but to formulate their expectations vis-a-vis investment, their objectives vis-a-vis investment in a short policy statement. That allows not only to provide some guidance to investors, but also to guide the national dialogue on investment. Of course, again, the investment policy should be adopted in a participatory manner, and it should really reflect the aspirations of the country vis-a-vis investment. Then nowadays you have very different models of investment policy statements. You have the one-pager of a large number of countries in the Caribbean, short to the point, indicating what the country expects to achieve from FDI. And you have the 190 plus pages of the India investment policy that is actually much more comprehensive than any investment law that I've seen to date. So there are various models. The idea is, at least in our advice, for countries that lack a clear enunciation of investment-related objectives, to have a concise policy statement, unless, of course, a law is called for. But again, that brings us back to the earlier discussion as to understanding when a law is called for or not.
Thanks, Kudzi. Back to you.
So next we can tackle some questions on the functions of investment treaties, notably again that we've discussed quite a few of these, but the first question was from Alexandra Reedhead, who asked about the place of domestic revenue mobilization in investment law. So her question reads, domestic revenue mobilization is an important policy priority for many developing countries. There is a risk that investment laws undermine this objective. Is there space to propose a new eighth function for investment laws to explicitly uphold and promote domestic revenue mobilization goals, or is it a risk to even bring tax or revenue into the investment law arena?
Elena.
Yeah, do you want to, I'd be interested to hear Massimo and Helen's thoughts on that question. I also have some thoughts, but Massimo, were you going to begin?
No, I was going to say that Elena already touched on it. Maybe she wanted to elaborate, but from our standpoint, it shouldn't be the case in the sense that we don't see investment laws as the locus for introducing incentives for a large number of reasons. One, because laws are more difficult to amend, and therefore once you've introduced incentives through the investment law, then it's going to be hard to adjust your investment policy, your industrial policy priorities accordingly. A second reason is that it is often the case that when you have investment incentives in the investment law, that is seen as a promotion tool in the hands of the investment promotion agency, with a mixing of regulatory and promotional functions, which creates a big conflict of interest risks. So the two should clearly be separate. What the investment law should do is to clearly indicate where investors can find the investment incentives. Again, context can be different. As for some countries, it may be warranted, etc. But this is the general approach that we follow and that is guided by our investment policy framework for sustainable development. Thank you.
If I may quickly react, I fully agree with what Massimo just said. Instead of adding an eighth function, I would say perhaps having 6 functions only would be a better approach, you know, and getting rid of investment incentives within the investment law. And as you said, Massimo, not only does it give the impression that the IPA is the authority behind it, but de facto the IPA is very often the authority behind the drafting of investment laws, because it's not only a promotional authority, I mean, an authority with promotional mandate, but also with regulatory mandate very often. And so they are not the best place to think in the most rational way of how to design an investment incentive scheme. So definitely leave it to the tax law and to the Ministry of Finance, I would say, yeah.
Yeah, I mean, just to echo, I think we're all agreed. Sorry. I did want to, we're all agreed that about the risk of undermining and that incentives are a bad idea in national investment laws. I mean, I think maybe I would take the question about possible 8 functions offline, but I think in principle, I agree with Helen. This is better left to tax laws and tax authorities. There may be ways indirectly that investment laws can support domestic revenue mobilization. This is not something we've worked through in the report, but potentially references to beneficial ownership disclosure in an investment law, that can be something that might indirectly support tax law and work of tax authorities elsewhere. So they may be potential indirect ways, but I think that's not an appropriate primary function for an investment law.
And if I may, Joseph, please, sorry to jump on the discussion, but I think it's related to this question, and also it will respond to one question on the Q&A regarding, again, if you are not providing any more fiscal incentive on your investment codes, what is the added value then? So, and I think as we said, actually that's mean you are in the right direction, because for us, if the function is not the appropriate one for your investment codes, then that should lead you to ask you the right question: what should be the function of an investment code? And is there a function this investment code can be appropriate? So it's really broad of a perspective, and then you can start thinking about all the issues maybe you didn't have in mind, and you can look on these the other function and investment law can pursue, of course, but you can go beyond, as we said, and think about new function your investment law can pursue. So I think actually that's a good question. That's an opportunity to rethink the investment laws and maybe find the appropriate function. And if there is no appropriate function, then maybe you even don't need an investment law, as Massimo and Elaine has pointed out. So yes, just to jump on the discussion and respond to this question at the same time. Thank you.
Great, thanks. I see there's been some points raised regarding the relationship between investment treaties and investment laws, and I see that Taylor would like to address one of the questions that was there about arbitration.
Yeah. Thanks, Joseph, and thanks, everyone. I want to echo a point that Massimo said about an important role for IISD, UNCTAD, the OECD, and others in really identifying risks and helping countries with that. And also something that Elaine said in her important advice would be to emancipate investment laws from treaty provisions. And I think my answer to Harshad's question combines both of these, that there's one treaty provision in particular that still appears in some investment laws and in our view really creates very serious risks for countries. And that's those laws that provide consent to international arbitration. And there are still some laws that do this. And I think there's been quite a bit of research and study that shows that the benefits of doing this are very questionable, if there are any benefits, and the costs can be very serious. So I think others may have other more nuanced points to Harshad's point, but I wanted to underline that I think if there are some individuals involved in the drafting or redesign of your investment law that are pushing for consent to arbitration, that this is something that should be viewed with extreme skepticism because it can create risks, again, as mentioned in the questions, of tribunals not doing a great job of interpreting other national laws, and also a risk of very large arbitration awards that don't necessarily bring benefits. But I think Elaine would like to comment, so I'll give the floor to you.
Yes, no, I very much agree with what you say, and I would like to add that on dispute settlement in provisions in investment law, instead of giving consent to arbitration, investment law should focus more on dispute prevention mechanisms, which has a strong role to play in investment facilitation and promotion.
I think we're all in agreement on that one, so I won't jump in.
Do we have still some more questions? We have the last probably 1 or 2 minutes to address perhaps one more question before we close.
We have 2 questions, Joseph. Susie would like to answer a question about just to clarify the difference between investment laws and contracts.
Sorry, okay, thank you. Yes, I think there was a question asking about how to make investment laws more transparent, etc. So I'm wondering if the participant is talking about maybe investment contract as compared to investment laws, since we are talking here about domestic investment laws. So by definition, they are public instrument and made available to everyone. So I just wanted to get a clarity if the question was really about investment laws or another kind of instrument like investment contract that may not be made public or come with some transparency issues. But yes, I think that's fine. That's just what I wanted to say.
Thank you, Susie. Joseph, do we have time for one more question?
I suggest that we're gonna close the webinar now. We have 1 more minute left. So I would first like to thank you so much to our amazing panelists, Ellen, Massimo, Susie, Jonathan, Taylor. It was really fascinating discussion, and I'm positive that our audience is enjoying it as well. And I also would like to thank to our interpreters, Evelyn, Kevin, Claire, and Alba for the work they've done on translating this live. So thank you very much. And last but certainly not least, to the entire IISD investment team and the project management team that helped to organize and logistically make this webinar happen. So thank you very much. There's certainly more in the pipeline on the topic of various legal instruments related to investment coming from IISD after rethinking investment laws. We're also currently trying to rethink investment treaties as well as contracts. So stay tuned and you will certainly hear more from us on these themes. And finally, I would like to kindly ask you to fill in our evaluation forms that you will find in the chat of the webinar, but also after you close and leave this webinar. It will take you only a minute and it will help us greatly to continue improving our webinars. So finally, thanks so much to you, our audience, for tuning in, and have a great rest of your day. See you soon. Goodbye.